So in the previous videos on this series, I was explaining because of the way the forms are set up and because buyer agent compensation is now part of a third-party contract, the listing agent's no longer negotiating total real estate commissions. They're just negotiating their half of the transaction. And the buyer and the buyer's agent negotiate the other half. So it's no longer the listing agent's money. And because of that fact, I've been explaining in every file where the seller is offering buyer agent compensation, contemplating it, they've requested it, they've paid it, in every one of those files, the listing realtor either breached their fiduciary duty because they had a duty to explain the risk of offering buyer agent compensation, but they cannot because they're not lawyers, so they breached their fiduciary duty but not advising the seller to talk to a lawyer. And if the transaction went through, they actually now attached or exposed liability to the seller for compromising the fiduciary duty of the buyer's agent, and perhaps being part of a keeping prices high and commission fixing scheme. They definitely exposed themselves, the seller, to that. And they should have had them speak to an attorney, probably before they signed the listing agreement. So in that scenario, which I venture to say most realtors probably said something like, well, you know, if the buyer agent commissions, if we try to counter that, the buyer could walk because it's part of a contract. So we won't discuss that. We'll just counter the price or closing date or something else. But in other scenarios, perhaps a lot of discount scenarios, discount brokers, but in other scenarios where the realtor helped the seller craft a response or negotiate a response to the G3 request, the box G3 gets checked, the buyer's agent's asking for buyer agent compensation. When that happened, the realtor practiced law without a license, unless they're an attorney. And oddly, that's not just a problem, it's a crime in California. That's what the Zipper case, I've been calling it Zipper. I didn't let the part where it said People v. Zipper sink into my head, but it's People v. Zipper that the DRE cites. That means the minute I saw People this morning, I was like, what, this is criminal? I didn't even realize in my previous videos, in this free video series at listingattorney.com, that realtors who counter buyer agent compensation, that I'm going to go into this more clearly today because it's very important, they could be committing a crime. Now, I'm not going to go, I'm sure a lot of attorneys, I don't even want to go further into what that means for the tens of thousands of times it's probably happened this year. But I am going to say, attorneys, my admonitions probably weren't strong enough before. You absolutely have to be, you really have a choice now. If you're looking to have a realtor get this property up on the MLS, you have to either be involved in protecting your client and counseling them, or you have to refer your files to a listing attorney like me, and who's a broker and attorney. And even if I'm not in Northern California, I will then co-broke on the file and I'll make sure you and your seller are protected. My information at listingattorney.com, I offer to train realtors who want to make a lot more money on these files, but properly protect their clients. But if that's not you, and you don't see that in your practice, in my opinion, you need to make sure an attorney broker is there. And that attorney actually needs to probably counsel their clients. And we're going to, because now it's a crime. I didn't even realize it was a crime for the last few months when I've been talking about this. But now I say it was People v. Seller. We're going to cover that. So let me go through this presentation. Well, that's the $200,000 we talked about. Now it's a third-party contract. This is where I'm explaining buyer agent commissions. The reason why it's different is that as a listing agent, I used to go in and negotiate. Real estate commissions are 6%. I'm going to offer half of them to a buyer's agent. And anyone working by buyer, it's me or someone in my office or someone else, they'll get that 2.5% or 3% that we're offering. So it was 6% buyer agent commission. It was the listing realtors commissions they were offering. So of course they were competent to negotiate their own money. And now it's not their money. Now they're not even allowed to talk about it. They don't have forms. They don't have language. It was all removed. We're going to get into that. So in every file, those are the potential breaches that we just talked about. Civil breach happens first. Like I think the breach of fiduciary duty happens the moment a listing agent starts talking to the seller, and they discuss the total commissions involved and how it works, because they're leaving out the risk. There should be a form for the California Association of Realtors. If they want to keep box G3, there should be a form that says you should speak to an attorney who's experienced in these matters before you sign a listing agreement. That really should be, because that attorney needs to explain to you the risks of offering buyer agent compensation, how to, like, there's ways you can leverage buyer agent compensation, market it, broadcast it. It can protect sellers from some fair housing concerns. It can help sellers sell for more money and get more showings and more offers. But you need an attorney to do this. That should be stated. Actually, really where it's going is I work with an attorney. They're on my team. We have a hybrid professional relationship, an attorney and a listing broker on every file. That's the way it has to go. Because I know they're not going to just give out, this form that needs to be done to protect. They need to give this form, and that's why you'll talk to my attorney first, or the attorney, your attorney, who's working with you. It can't be the in-house brokerage attorney protects the realtor. It needs to be someone who's there for the seller and can put a lot of time in and do this properly. So, the first breach, the moment it's seller, if they're no, we are not paying buyer agent commission and it's not going to change, we're good. The moment the seller could change their mind or contemplate it, that's when the attorney needs to be involved, counseling. I mean, really, I'll get into the counseling in another video. That's not for this one. Okay, so these are the risks. Some of them: steering, compromising the fiduciary duty of the buyer's agent. Steering and compromising the fiduciary duty of the buyer's agents built into almost every file. And because it's built in, you now have potentially the class action argument that realtors are keeping commissions high. And we know buyer agent commissions went up in 2025 due to these policies around the country and the way the forms are being written, and the fact that really it comes from the fact that the associations and the MLSs are forcing buyer's agents to make the buyers agree to an amount of compensation before they even show the home. I can speak to this. In California, that's not the law. The law says that amount should be put in writing no later than when the purchase agreement is executed. So it's not before they see the property, but that's the process. And so therefore, built into this process now are those risks that DOJ warned us all about. So if they don't explain, it's a breach of a fiduciary duty. If they try to explain, it's the practice of law with unauthorized practice of law. Now you can see I had an AI help me build these slides. So now it's telling me here, I'm going to bring over the purchase agreement to show you the issue. So let me move it over here into the first slot. And now I'll bring it over here. And this is a purchase agreement. Let's say the house was listed for 1.6. The offer comes in at 1.4 or 1.5. And this is what we're seeing. The buyer and the buyer's agents check box G3 and they're requesting the max, in my experience, or close to the max for the area. 2.5 or 3%. You figure it makes sense. They're like, if I got to reduce it to writing, I might as well say, well, that's what I charge, but don't worry, we'll have the seller pay. And that's what they're doing. Now, why can they even say that they're going to have the seller pay? Well, one thing is the listing agent has no forms to counter. They have no listing. They're not authorized to discuss or negotiate buyer agent compensation through their forms. There's no written authorization. I advise every seller, any attorney who wants to follow our method, our listing attorney method, I'd advise that you get authorized in writing to negotiate, or you make sure an attorney is authorized in writing to negotiate, that they can actually get on the phone when the parties are $10,000 apart and get that deal closed by having the buyer's agent, and maybe the listing agent could kick in some of their fee together to get this deal done. Like, you need someone authorized in writing to negotiate it. But, I can also tell you that in the CAR database, there's no forms related to buyer agent compensation for the listing agent to use. And they tell you here, they removed all forms related to cooperating broker compensation, nor does CAR include any other forms in its library of forms that might facilitate such offers. That's because it was reported in the press that DOJ put pressure on them. I believe that came after one of my videos saying, how can a listing agent advise a person to sell their home and offer buyer agent compensation when the DOJ just showed us in these class action suits that, for instance, the Massachusetts PIN case, they stated that the buyers would be comforted in knowing that their agents aren't incentivized to have them pay more. Like, how are you going to mitigate that risk? It can be mitigated. But how is a listing agent going to do that? How's a listing agent going to evolve steering? Going to help their client with respect to steering when you know it's built into these forms. I mean, for instance, many times a seller will have an offer in their hand from a buyer. The buyer's saying, this is how much I'm willing to pay. What do you need a buyer? What do you need to pay a buyer's agent for after that? You've already got the contract in your hand. Well, the threat is that if you don't agree to pay it, they're going to force the buyer to walk because they've got a contract. So steering's built in. Now, I've explained the risks. Now let's talk about the counter process. Now this is what a listing agent has to work with. Boilerplate and then terms. This is where, let's say you're countering the purchase price. You'd say box A3 is hereby 1.6 million or something along those lines. And this is just a suggestion. This is not the language I would necessarily use, but then you'd write box G3, that's this box, is hereby unchecked. Any request for compensation to buyer's broker must be made in a separate written agreement between buyer and seller and is not a term of this purchase agreement. What would that do for sellers? It would help them with the net and probably help them with their final selling price because you've now bifurcated the process into two separate negotiations with two separate forms. In that other form that you could attach, or you could say a blank form hereby is attached, you could also do your risk mitigation for steering, for compromising the fiduciary duty of the buyer's agent, maybe even for the commission fixing. I'll have other videos and training about that over time. I've already put some of it in the free members area that people who go to listingattorney.com for the membership series are going to see some of that training in that area. Now, for those who are now wondering about whether it's really a crime for a realtor to do that, I mean, why can't the brokerage just do what they always do and have like a little forms area? Okay, well, first of all, the separate forms of mitigation are very important, and not every seller is going to want to make every buyer jump through every hoop. You can mitigate the risk of this, I'd say 100%, by offering zero buyer agent compensation. You could probably get close to 100% by forcing the buyer to jump through certain hoops. You could probably get a very substantial way mitigated just within this box here. But really, if you're trying to help a seller, why wouldn't you separate the negotiations for the price of the home and the other terms like the closing date from the buyer agent compensation? Because as each round goes on, that buyer agent's going to know they're about to start negotiating my commission because we're still far away from where that seller wants to be and their net's hurting. I know they're going to nail me on this now. And by separating it out internally, I mean, everyone's human. That buyer agent's going to be working harder to get this deal closed sooner, probably at terms closer to the seller's price. So right there alone, you're going to get your seller a better price. Chances are, probabilities are. Two, let's say you're not getting that better price. Well, eventually you will negotiate. If you've put this in every round of the negotiations that it's not officially the buyer's agent is not officially being paid yet, you can then go back and make that final round 1%. And that really puts the agent and the buyer in a bind because the agent has a duty to put the buyer's interest ahead of their own. So if you match the buyer on price but cut the buyer's agent comps down to 1%, I think ethically they have to advise their seller to do the deal, and they can't stand in the way by saying, but you got to come up with another $20,000 for me. So all of that, massively important that it's done right for a seller. Realtors aren't licensed to do it. But now, just technically, even writing this in or choosing whether to put on this paper or break it out into two separate contracts. This is the law now. This is People v. Sipper. That means this is a criminal case. City attorney is trying this case. Well, I guess they could also do civil cases, but it's People v. And I did the research. Google AI and ChatGPT both said this was a 6 months situation. So here is the wording. Well, it starts a little bit above, so. But in the larger sense, it includes legal advice and counsel and the preparation of legal instruments and contracts by which legal rights are secured through such matter or may not, depending in a court. I don't even know what that means. They have uniformly said as a term is generally understood the practice of law as the doing and performing services in a court of justice in any matter depending therein throughout its various stages and in conformity with the adopted rules of procedures. But in a larger sense, it includes legal advice and counsel and preparation of legal instruments and contracts by which legal rights are secured, although such matter may or may not be, depending. And I think that's just a word from the 40s. We would say may or not be in court. But this is the part that's obvious here. It is apparent that what defendant did come squarely within this definition. They chose to help the parties write a deed and use a deed framework. If defendant, and that's the defendant is the person with the real estate license, had only been called upon to perform and had only undertaken to perform the clerical service of filling in the blanks on a particular form in accordance with the information furnished by the parties, for instance, the price and the address of the property, or they had, and the closing date, or had merely acted as a scrivener to record the stated agreement of the parties to the transaction, he would not have been guilty of practicing law without a license. But the record supports the conclusion that he went further, that he determined for the parties the kind of legal document they should execute in order to effectuate their purpose. This constituted the practice of law. Now, I think that you could break this down and say in this counter, as realtors have been doing for a long time, that if they're just saying this, the seller wants to counter as the price and seller is countering the terms, and you know, choosing the words might be practicing law, but I think it's been going on so long, I wouldn't make my stand. I would expect the courts to say that's ministerial. You know, they're effectuating the desires of the party. But when they decide to do a counter for buyer agent commission, which is now part of a third-party contract, and by allowing the seller to agree to pay buyer agent commission, they are now exposing, if not, because it's the realtors. If the realtors were using forms that didn't have a box G3 checked, it could be a different analysis. But because that forms that they have, that G3 box is checked, and you need to negotiate that every round if you want to keep it alive, because that's how this works. You're not going to go through 3 rounds of price negotiation and then reintroduce it. That's a bigger problem than keeping it alive the whole time, because of the way this says it. Like, you've accepted those other terms and you're moving forward. So, you know, it would be bad faith to open it up later. You have to keep it alive every round. You have to choose how to mitigate those risks. The seller has to be made aware. There's just no way that that's not practicing law without a license. And therefore, it would be a misdemeanor in California for them to do so. So between the Sipper case, People v. Sipper, and the fact that buyer agent compensation is now a third-party contract, and there's risks of paying it and offering it that are significant, it's either breach of fiduciary duty for not bringing a lawyer in, or it's practicing law without a license, which is criminal. So, for more information, I know I want to be challenged. Everybody you're willing to challenge. I'll do more videos on this. They're going to be available at listingattorney.com in my free membership area. I will talk to sellers, realtors, attorneys. The whole reason I picked the listing attorney URL is because not only this isn't just about the negative. This is about the fact that prices were last time we looked have gotten weaker. They're going down. We're not seeing as many strong offers. We're not leveraging buyer agent compensation the way realtors used to. And I think it'd be advantage. Everyone used to do it on the MLS. It's not on the MLS now. But you could still leverage buyer agent compensation to get more showings. And in California, in my experience, was between 5 or 10 showings from real agents, you're going to get offers. If you're not getting an offer, something's wrong with your home, or your price is probably 10 or 15% out of the market. And it's so absurd that people are like, I'm not even going to try this seller's bananas. But if you're getting 5 or 10, whether it's at the first open house weekend and all the buyers are coming through, the buyers are coming through with your buyer's agent, or with your listing agent, or buyer's agents are coming through, you get showings, you're going to get offers in California. And that is because in part, you want more showings, and you could get more showings by leveraging buyer agent compensation in social media on open house. Like the coolest thing, doing open houses. It's not because the open houses are great. It's because of the internet portals now, like put little boxes around in gold and highlight your house so it pops up in everyone's eyes. So there is reasons to leverage buyer agent compensation. There are reasons to say open house, realtors welcome, buyer agent compensation is being offered. It protects against some of the risks of offering inconsistent buyer agent compensation. So that's it. There's more at listingattorney.com, but I just felt, I got a little pushback on this recently, and I just wanted to make it clear why it's practicing law without a license. And then when I actually reread the case, that's when I found out it's actually a criminal matter. Thanks. Talk to you later. My name is John McConnin. I'm a broker and attorney in California. The California Association of Realtors has had me train realtors on negotiating multiple offers in the past. And you can find out more. I have a free video series at listingattorney.com, and I have put together programs to work with realtor attorneys who refer their clients to realtors, whether it be in Southern California with me or outside of Southern California. And I obviously can refer sellers all over really the country to do this the right way. I can't talk about the process outside of California as much because that might be practicing law without a license. And I really want realtors, because I'm a broker, to do this well. So I'd say go to listingattorney.com and ask me what I've developed for realtors. I have an idea. Hopefully be ready by January. It's the middle of November right now. Thanks. Talk to you later. Bye.